Good day, everyone. My name is Dan Sampaio, and I'm delighted to welcome you to today's webinar in association with İllig Gürkaynak Attorneys at Law, which will discuss the Turkish competition law regime, the differences and convergence of the regime in Turkey and the US, and how these may be adopted for the nascent Turkish settlement mechanisms. We are joined today by a brilliant panel. Mr. Gönenç Gürkaynak is a founding partner of İllig Gürkaynak Attorneys at Law, a leading law firm of 90 lawyers based in Istanbul, Turkey. Mr. Gürkaynak heads the Competition Law and Regulatory Department of İllig Gürkaynak Attorneys at Law, which currently consists of 48 lawyers. He has unparalleled experience in Turkish competition law, counselling issues with more than 20 years of competition law experience, starting with the establishment of the Turkish Competition Authority. Mr. Bilal Sayyed is currently Senior Competition Counsel at Techfreedom. He was most recently the Director of the Office of Policy Planning at the Federal Trade Commission 2018 to 2021. Prior to his time at the Commission, Bilal was an attorney in private practice, representing clients in merger and non-merger matters before the FTC and Department of Justice, and in consumer protection matters before the FTC. Bilal also teaches antitrust law as an adjunct professor at the Antonin Scalia Law School at George Mason University. Now, before we get started, here is how you can get involved in today's event. You have the opportunity to submit questions to today's presenters by typing them into the questions pane of the control panel. You may send in your questions at any time during the presentation, and we'll address as many as possible during our Q&A session at the end and throughout of the presentation. I would now like to hand you over to Mr. Gürkaynak to begin today's webinar. Thank you.
Thank you, Dan. It's a privilege to be talking with Bilal today. We will be discussing antitrust settlement practices, both in terms of mergers and in terms of conduct practices in the US and in Turkey in a comparative fashion. There are lessons to be taken from the US experience, both for the Turkish jurisdiction, but also for very many other jurisdictions, as the US regime has been using settlement mechanisms for a long time. Needless to say, because we will be looking into settlement mechanisms in the US as well, much of our discussion may focus on merger control aspects of settlement issues, as this is more prevalent in the US in terms of the impact of settlement. There is a new regime in Turkey in settlement negotiations and settlement practices, and that relates to conduct. So we will be discussing the conduct bit as well. But without further ado, maybe I'd invite Bilal to provide some comments on what was the previous practice in settlement matters and where is it heading when he looks at the merger control issues and the settlement practices in the merger control context.
Okay, well, thank you, and I'll second what you said. It's a privilege to do this, and I'm grateful to do it with you. Leading antitrust lawyer in Turkey and extensive experience all over Europe. So this is a nice thing for me to be doing with you. So it's funny. I was just as we were starting, I was looking again at the title of the webinar, and part of the title is the developed regime in the U.S. Well, there is a developed regime in the U.S. in terms of enforcement and settlement practices, but there appears to be the potential for a significant change in what the antitrust agencies do over the next couple of years. And assuming that happens, it'll also be interesting if that sticks over time. So let me support that statement. And I'll go back a little bit. Way back when I first started to practice, roughly 25 years ago, the agencies did not really pay a lot of attention to settlement issues in both their merger and non-merger work. the Hart-Scott-Rodino Act, which is the merger notification regime, was promulgated in the mid-1970s to sort of address the difficulty of remedying problematic mergers after the fact. But in the roughly 20-year period between the time the Hart-Scott-Rodino Act was passed, which required pre-merger notification, and the mid-1990s, not a lot of attention was paid to settlement, making a settlement work well. In the mid to late 1990s, the FTC began or did a study of their remedy provisions in merger matters, and found what I'd call significant holes in what they were doing. And the basic thing they found was that certain remedies were not working, and they were not working because the parties had a relatively long time to divest assets that were required to be divested in mergers, and those assets often, once divested, were not successful. The buyer of those assets was not successful in becoming a competitive force in the relevant market that the agency was concerned about. So for 20 or so years, the agency had sort of worked hard, particularly the FTC, but also the DOJ, had worked hard to put real substance into their settlements by requiring, on the merger side, by usually requiring the parties to divest assets quickly after their merger, the primary merger, was consummated. The agency also usually required, in conjunction with that kind of quick divestiture, usually required the parties to come in and present the buyer, or have the buyer sort of make the case for why they were going to be an effective competitor with the assets, that they would acquire. In addition, depending on the complexity of the divestiture agreement, whether it contained, some continuing obligations between the divestor and the acquirer of those assets, the agency would particularly the FTC, but DOJ was moving to this too, would require either some kind of trustee, somebody from outside the agency, to oversee the divestiture, to oversee that the company, again, the divesting company, was living up to its obligations, and that the divestiture was, at least as a matter of process, was successful. But notwithstanding these types of requirements, the agency was largely open to resolving most merger matters that raised antitrust concerns through, some kind of fix, some kind of divestiture. Most of the divestitures were in horizontal merger matters, and were the divestiture of something either exactly of an ongoing business or something that could be viewed as an ongoing business when the assets were fully packaged, in a sense. The process, and the question we have now, is whether that process will change on the merger side, or and how. And I'll come back to that. On the non-merger side, of course, again, the agencies over the last 20 years have paid, I think, a lot more attention to whether the remedies associated with a significant non-merger investigation, let's say a monopolization investigation, have paid significant attention to whether the parties who were affected by the conduct of the defendant or respondent in that matter paid significant attention to whether those firms believe that the conditions imposed on the respondent or defendant as a condition of settling a significant monopolization case, whether they believed that the settlement would sort of address their concerns. So for conduct settlements, it's usually sort of very highly regulatory structure put in place as to what things the respondent or defendant could do. So now moving, and that required a lot of interaction with, like I said, sort of the affected parties. I know when during my 2 times at the FTC, when the Bureau of Competition was trying to settle a major monopolization case, it was not unusual to see, major customers, representatives of major customers of the target of that action in the building negotiating or talking with the Bureau of Competition about the terms of the settlement that either the agency was prepared to propose or the parties had, or the respondent had proposed. So now let's move forward a little bit. There's a belief that the new approach is needed to antitrust in the U.S. that by some people and basically by the leadership of the FTC, and I think also the incoming leadership at the Antitrust Division of the Department of Justice, and clearly the Biden administration as a whole believes antitrust enforcement ought to be ramped up from where it's been the last 20, 30 years. I disagree with that in many respects, but let's accept that for true. So what are we likely to see? I think there's going to be a stepping back, particularly at the FTC, but this may be true at the Antitrust Division as well, in the willingness to accept settlements in merger matters. Now, there is a significant skepticism at the FTC, particularly in the leadership of the FTC, Chairman Lena Khan, about whether mergers have been good for the economy or not. And I think you're going to see a lot more, at least an attempt to block more mergers and not accept settlements. In practice, that may be difficult because the agency can only litigate so many cases. But then what I expect you to see is efforts to make the divestiture process more onerous. And I mean that in 2 ways. And I don't mean just more complex, I mean more onerous. I think that they're going to want to see a lot more assets divested, and I think they're going to vet the buyer much more aggressively than they have even in the recent past. And I think the purpose of that is to encourage the parties to abandon the transaction and go away. Of course, if that doesn't happen, I expect the process to just be longer and more complex as they, attempt to increase the certainty that any divestiture that they accept will be successful. On the conduct side, I expect to see the same thing in 2 respects. First, there's a suggestion that there'll be more monopolization cases opened. And those are complex, both to bring and to settle. But of course, those you have to settle, or the conduct continues. I expect to see an effort to try to get structural relief in monopolization cases, as opposed to what you've seen in the past, which is mostly conduct relief. And I expect to see a lot more of these cases. And I expect to see highly regulatory approach. And in some instances where there is, as I said, sort of vertical integration by the respondent or defendant that arguably is sort of the cause of the problem, I expect the agency to push for structural separation. They talk about it. People talk about it in the context of Google or Facebook or Amazon. But I think it's something they're going to push for in their significant monopolization cases, and that would be significant. Now, whether they'll succeed is a sort of I think, an open question, but that's what I think you're going to see. So I think there are going to be major changes, or at least an attempt at major changes, and an interest in advocating for major changes. And I expect that to spill over into what I'd call sort of the nascent regimes, not only in Turkey but other places. They'll look to the U.S. and the EU. So I'll stop there because that's a lot.
No, it's very interesting. Would you think that the timing issues and the foreseeability issues are going to be in the heart of the risk factor for transactions? Because it seems that the FTC is going through a change in terms of their tendency to tie up concentrations. And if their tendency to tie up concentrations is increasing, it's one thing to say they're going to be more draconian, they're going to ask for more, they're going to be more geared toward requesting structural changes, but at least there's some, timing and rhythm of something, and they're just more aggressive. But it's quite another thing if they were to feel that they're questioning if mergers are good for the economy anyway. What are we doing with all these concentrations? So another way of killing them, and a more effective way of killing them, is actually being more silent, at being at the receiving end in the negotiations, not getting back to the counterpart in good timing, and diminishing the foreseeability so their asks wouldn't have enough benchmarks and all that. This is being used as a technique elsewhere in the world. I'm not saying in Turkey, but we're experiencing this kind of an attitude by some antitrust agencies. Do you think the FTC might be going into that kind of a trend as well?
Well, I'll say yes and no on that. Look, I think the agency, prides both agencies, the Antitrust Division and the FTC, pride themselves on professionalism and transparency, and in a sense working above board with the parties. So in that sense, I don't think there's the staff, as an example, the staff will go what we call pencils down on talking with the parties, right? I think they're going to continue to do that. But I think there are two limitations on what I said. First, as a matter of practice, the staff in the Bureau of Competition will only move forward on settlement discussions when they get approval from the front office management of the Bureau of Competition, or management at the Antitrust Division. They will only move forward on settlement discussions when they get approval to do so. And I think that approval may be slower in coming because of the interest in pushing back on just mergers generally. We see something like that in the move to stop granting early termination of the waiting periods for mergers that are notified to the government. In the past years, something like roughly 70 to 75% of transactions received early termination in the waiting period, something shorter than the statutorily mandated 30-day waiting period. Now, starting earlier this year, in January or February or so, the agency stopped granting early termination of the waiting period. So every transaction that comes in with really with no exceptions is forced to wait the full 30 days to clear their transaction. Now, on the margin, this may have some effect on the willingness to do transactions, the timing of transactions. But I think it's evidence of this larger point, which is the agency wants to slow down mergers in the, happening in the United States or that affect U.S. markets. And, one of the tools they're going to use is the process protections they get that prevent the parties from consummating their merger until they comply with a second request. The second requests have, and you see that now, right? The second requests have had some new questions added that relate to what I call non-competition matters, or are a broader interpretation of competition matters than you've seen in the past. And that is slowing down the ability of firms to respond to the second request and, in a sense, put the agencies on the clock of having to make a decision. The agency has announced, so-called new processes to strengthen the second request process, and those will add, delay to the party's ability to get not so much, to get their deals through, because it's going to delay feedback from the staff on what is sufficient to comply with the second request, what are, the issues that they're focused on. So I think it's not just going pencils down, right, and saying any time, it's putting new things into the process that, I think at least the leadership feels is justified. And that's going to slow things down as a matter of process. That's using the process to slow things down in a way that is at least intended to reflect new concerns and new ideas, but may be on what I call shaky substantive ground. But it's a way to use process to slow things down.
Yeah, no, it's very interesting. So in comparison, in Turkey, on the merger control side, you do have the tendency that the authority would only start speaking about the possibility of a settlement once a phase 2 is opened, which is a problem. So when a client is requesting feedback on whether they should propose certain commitments, whether they should try to settle the matter at hand before it falls into a phase 2, it is a rather one-sided street. So what happens in a phase 1 is that the case handlers think, rightly actually, unfortunately, that the Turkish Competition Board has not authorized them to negotiate with the counterparts about what commitments and what kind of a settlement could be acceptable. The board has not even at that stage articulated the existence of an issue. So if the case handlers of the Turkish Competition Authority were to heavily engage in a negotiated settlement in phase 1 and then bring it to the board saying, here is the deal that we have negotiated with the counterpart, isn't this great? Board members of the Turkish Competition Authority are known to say that they feel the case handlers have been out of line in engaging so deeply in these discussions in phase 1, because the board hasn't even spoken as to their substantive perception of the matter. So only if I were to take it into a phase 2, then you would know that there is an issue. Then I understand why you're getting vested in these kinds of negotiations, but why would you do this right now? So conversely, what has happened over the years is that in a phase 1 situation, if you as the applicant are already sensing that there might be a phase 2 at the end of this, because this is a 3-2 kind of a matter, or there are issues, then it's a very schizophrenic kind of an approach to the authority, where you're negotiating with yourself basically. So you provide a commitment and a settlement to the authority. The case handlers say, they look good, but I can't comment on it, but I would be happy to feature it in my report if you would like to leave it as is, and I'll bring it to the board. And then you say, yeah, but I mean, are you saying that it's enough, or what do you feel? And they would say, I mean, if you want to up your proposal, obviously, we'll then feature that with the board. So it's not a great idea to engage too deeply in a phase one situation, because you get salami sliced, basically, not out of a bad will, but out of this peculiar understanding in the procedure. Now, the problem is, if you were to fall into a phase two, then it's time consuming. So luckily, at least, phase two in Turkey is not defined as 3 layers of written allegations and then 1 oral hearing. It doesn't have to happen that way. It is defined as such, but you can stop the procedure early. That said, once you fall into a phase two, you're easily looking at 3-4 months in the quickest wrap up of a phase two in a settlement. So if you're feeling that you have the silver bullet in phase one, and you're just not sure as to whether you should use that silver bullet in phase one, it's a true dilemma. It's a true issue, because you find yourself in a catch-22 situation. If you fire the silver bullet, yeah, you're going to get the decision with the qualification of the bullet, but then should you have done it, or did you overdo your line? Maybe they were going to give you an unconditional approval because, you know, it was a borderline case, say. And again, if you were to wait and it falls into a phase two, then suddenly, even if you were to fire your silver bullet, the quickest wrap up is going to take 3-4 months of review time and some risks in this matter being featured. So that's on the merger control side of things, where things get a little hairy. Once it's phase two, the landscape is perfect, actually. The case handlers discuss with you properly, the file is transparent, their concerns are transparent, there is an understanding as to why they are holding on to this transaction. You may or may not agree with it, but at least you know how to address the issues at hand. On the matter of conduct related settlement, this is a very new thing. We're talking about this summer, 2021, in July, a new legislation has passed. And with that, the secondary legislation that is, and with that, now settlement negotiations on the conduct side are possible. Before, we didn't have this. And because we didn't have this, a lot of cases that could have been settled very easily, actually, because they were more like liberalization projects rather than matters of severe, conduct. They couldn't be settled. Now, with this new regime, you have from 10% to 25% discount on the administrative monetary fine applicable. So this suggests that the client that would approach the authority would feel safe and secure in believing that there is going to be some form of determination of a violation at the end of this anyway, or what they're proposing to offer to the authority isn't going to hurt their business model anyway. We have had these instances already from July until now. In the few months that have passed, we've had multiple settlement approaches for clients, and our impression of the process was that the authority wants this to live. We've made this mistake in the leniency procedures. The Turkish Competition Authority has done, in my view, grave mistakes in its handling of the leniency regime. So they have raided certain entities that have done leniency applications just to see if they were just showing the tip of the iceberg, or whether the leniency package was truly full and genuine. And obviously this has meant that leniency applicants started feeling that they're going to be received in an hostile environment. There were certain instances where the Turkish Competition Authority still questioned the practices of the leniency applicants, and there was a bit of a legal uncertainty. So in terms of the handling of our leniency regime, we have given very confusing signals to the businesses. which has been detrimental on the efficiency of the leniency regime. And over the years, it hasn't been used much, in my view, because of those past mistakes and wrong policy preferences as well. Now the authority, with this new legislation on settlement, is particularly keen on giving a good vibe, and they just want to make sure that whoever is approaching for settlement is getting a candid counter approach from the authority. So, and the system is quite good as well. You engage in settlement negotiations at any time of the process, and then these negotiations are recorded with meeting minutes, and the Turkish competition authorities case handlers are discussing with you without prejudice, and they can actually say to you at some point that now what you're suggesting is good enough, we will take it to the board, and the board gives back some feedback on it. They may say, I'm ready to take on this as a settlement, interim settlement decision. So they would then issue an interim settlement decision. This would give the legal certainty to the approaching party. Then you would actually do the official settlement application on the basis of that interim settlement decision, and it would turn into a holistic settlement. Now, what could go wrong in there? We have experienced this actually. Wrong, not in the sense of what I have described in the leniency side, but wrong in the sense that the case handlers agree, but the board doesn't agree. Now, if the case handlers don't agree, it's not much of a hiccup, because then you know you're proposing something and they're rejecting it. But if the case handlers were to say, oh yeah, okay, we think this is good enough, and they take it to the board, then of course there is this bizarre situation of the board knowing that a settlement approach has been devised by the applicant, and if the board rejects and requests more, and if the client is not prepared to take it on, which has happened in a recent file, then it's a bizarre situation, because you are continuing the investigation, and you could be defending that you are entirely innocent in all of this, and that there should be no finding of a violation. And meanwhile, you have in the track record, you have approached the authority and said, I could change this and I could change that. We've had that kind of an interesting oral hearing where I was explaining to the board that in the history of this file, actually, we did approach you. Your case handlers liked what we have approached with, and they took it to you. You didn't like it, and you wanted us to up our hand with certain aspects. Then in turn, we didn't like it, and we said, no, this is asking for too much. Then we're going to take our chances with this procedure. So we rejected the whole thing, and the board said, fine. Now we're before you, dear board, as the same entity, saying what you rejected wasn't even necessary, and you should not have upped your hand. And meanwhile, we haven't done anything wrong. Thank you very much. Now, it's a tricky kind of handling, but kudos to the authority. The authority actually managed to listen to what we were saying. I mean, it's not a virtue in and of itself to listen to what we were saying, but it is a virtue, I think, to listen to the defense with a broad mind and without being too impressed with, well, we will have to come up with a finding of a violation because they were prepared to give us something and we didn't take it, and now they can't just walk away. So the board said, no, we hear you, and we will actually ask for the entire industry to come forward and give some concessions, and it should be on an equal footing, so it can't be only you guys offering a settlement on this matter. And meanwhile, we don't believe that you've done anything wrong. This looks more like a liberalization project to us. We're giving you a new positive duty, and there shouldn't be an administrative monetary fine attaching to it because there wasn't a wrongful act. But still, now we're changing the landscape. If you want to take this decision to the Turkish administrative courts and challenge us on our liberalization side of things, be our guest. So it was an interesting handling of that issue. We also have under our belt successful settlements already within the few months that have passed, and these successful settlements were also quite interesting in the sense that they were negotiated thoroughly. In some, the board was already happy with what the case handlers said. In some others, the board said, I would like more from you, and there was a common ground that was found ultimately. But the legal security was there, and the settlement has worked. So far, they have been using the upper limit of their reduction capabilities, so 25% reduction. And in the general terms of things, I would say that the 25% reduction of administrative monetary fine seems to be more likely to be used in the short-term future, because they would like to give out the signal that there is an upside of approaching, and 10% of discount, considering the fact that this is Turkish turnover of the entity, may not be that meaningful to especially to multinational companies, because what you're giving away is your ability to take it to court. So if you settle under this regime, you cannot take it to court, which in turn means that you're opening yourself up to private enforcement cases. And Bilal might be amused to learn that Turkey is one of the few countries, apart from the US, where there is a treble damages clause. So unlike the EU system, we have treble damages in our legislation, which in turn means that if you open yourself up to that kind of litigation, especially if you're a gang of entities that are being investigated and you're the only one that has settled, you're basically becoming a flag bearer in the private enforcement lawsuits. So in turn, most clients would feel that if they're going to forego their ability to take the decision to judicial review, at least in return, they should be getting a 25%. Obviously, when we're looking at the merger control side and the conduct side and the commitments versus the settlements holistically, these terms may have mushed together a little too much in my presentation, but ultimately I should warn the people who are following that ending an investigation with commitments is a different thing under Turkish law as compared to ending it with a settlement. So in the settlement scenario, you have to recognize that you were a party to a wrongdoing, and you would actually give whatever you have about the nature and the scope of the alleged violation, the evidences, and all that. The authority would signal to you the reduction rate that they're thinking of, and before you actually file officially for settlement, you already have a lot of certainty as to what is going to happen if you do. In the commitment side, it's a bit more mysterious in the sense that you come up with your best commitment within the prescribed time limit, but ultimately, if the board doesn't like it, and if you continue your way with the discussion that you haven't done anything wrong to begin with anyway, there is that schizophrenic oral hearing that is happening at the end of the procedure, where you're trying to explain that yes, you did come forward with a commitment, but it was because either you felt that the board could be doing the wrong thing at the end of the investigation, so you wanted to take your best shot at it, but then the stakes became so high that you decided to yell what is the truth, which is that you're not guilty of anything. Or alternatively, you're discussing that what you have proposed to the authority wasn't interfering with your business model dramatically, so it was easy for you to propose, and if they felt that this was solving the issue, then you were happy to propose it. But if they felt that you had to up your hand, as they did in that instance, then you didn't want to proceed with that line of thinking. So it is interesting in the sense that in Turkey this is triggering a lot of contacts with the case handlers and division heads, which is not in the culture. So the competition authority is quite a private place. We don't have the same type of revolving door either. Like, you can't be going to the private practice from the authority and then coming back to the authority. It's a one-way kind of a thing. So all of these are meaning that the discussions that are happening around settlement and negotiation of commitments, these are somewhat new in terms of conduct, and it can be a bit too static, basically. So you might feel like it's not that much of a negotiation, but the authority is telling you what it wants. You either take it or you leave it, but you know, it's not easy to mold or find alternative solutions or get articulations of what the issues are. Sometimes also for a lack of a benchmark. Sometimes it is difficult to work on what the Turkish Competition Authority is talking about because they don't use benchmarks the same way some other jurisdictions would. For example, if you are discussing a technology-related market and you're trying to talk about, you know, what this type of commitment does to free clicks, how it increases the organic results, or you know, anything that requires a study of the market. And if the authority is talking more in the language of narratives, then it's very difficult to. It's more like two ships passing each other in the nighttime, basically. So it's difficult to reconcile the differences. And these things can happen, especially in technology markets, I find. Back to Bilal on whether he would like to speak about the settlement prospects in technology-intensive markets, and whether the challenges of the new markets are presenting challenges also for settlement issues.
Well, that's a good question, and I think a good topic. In some ways, of course, we don't fully know the answer. You know, I think there is a skepticism of large firms operating in, you know, what we'll call technology markets. There's a lot of focus, you know, publicly on the big three or big five of Google, Facebook, Amazon, Apple, and Microsoft. But you know, there's a lot of interesting technology markets that are not arguably so public facing. I think there is a desire to engage in some structural separation with respect to conduct by those firms. You know, that I think the agencies have for a long time said, and I think correctly, that you know, monitoring the conduct of a company and whether they're sort of complying with a settlement related to, you know, a conduct effort is difficult. And I think that companies and commentators have also said, you know, these ongoing conduct restrictions have a significant effect on the ability of firms to be sort of innovative and flexible and responsive to customer needs. And, you know, I suspect there's going to be an attempt to avoid regulatory type decrees for both reasons, and move to divestiture or structural separation of, you know, sort of the parts of the firm that you know, sort of allow from the agency's perspective, allow for the conduct that they're concerned about. Now, the agencies rarely get structural separation in monopolization cases. Certainly, it's not something you get in litigation. and it's rare they in the past have advocated for and received it in monopolization or monopolization type cases. But I think that's where it's headed, and I think those become in some ways more complex to move forward on. And I think what parties will have to do, and this is true on both the merger side and the non-merger civil side, is really think hard about whether they're prepared to settle these matters or put themselves in a position to litigate these matters. Although it wasn't a case of structural separation, in the Qualcomm matter that the FTC bought, there were significant efforts made to settle that matter. I don't think the company believed it needed to settle, but they were interested, I assume, in avoiding litigation risk. And so there were, extensive efforts to settle the FTC's case against Qualcomm after the complaint was filed. But of course, in the end, Qualcomm was found not to be liable for illegal conduct by the Ninth Circuit. And so the willingness to, in a sense, walk away from a settlement, what may be an onerous settlement, may be what parties are going to have to do, and take their chances with litigation. The agency's record, sort of on what I'll call the non-merger side or the or the consummated merger side this past 18 months or so, has not been good. The Facebook case was dismissed by a district court judge. He did allow the FTC to refile, but that was significant, I think. The agency pursued a case, a restraint of trade case against 1-800-CONTACTS, which was not looked upon favorably by the Second Circuit. And of course, the agency pursued a monopolization case against Qualcomm, and the Ninth Circuit did not look favorably on that case either. So, in times where someone like myself and maybe even yourself are concerned that the FTC and the U.S. antitrust agencies more broadly are overreaching, the right approach may be just to get yourself, for respondents or defendants, merging parties, to get themselves in a position to litigate the issue, because with the agency potentially attempting to install sort of a new framework for merger and non-merger review and settlement, it may make sense to just put them to the harder case of having to prove their case to a court. So, I think, and that ties back to the question of tech, because tech markets are complex. These companies bring a lot of benefits to the economy, and the agency may have a difficult time showing both their relevant market and that the conduct, the so-called harm of the conduct is not overwhelmed by the efficiency benefit associated with the firm and the conduct and their actions.
Yeah, agreed. Also, it's very easy to engage in scaremongering in technology markets. So you may be going into an enforcement where if it's not instructed enough by a counterfactual analysis, by an economic analysis, by a proper effects analysis on the ecosystem, you could actually be engaging in perverse enforcement if you strike a deal of settlement on grounds that are going to be detrimental to the rest of the ecosystem, or on certain aspects where the dynamic efficiencies that would be expected in the near future cannot be realized. it's interesting. These things are a bit one-sided these days. Whenever competition authorities are articulating a problem, a theory of harm, dynamic efficiency issues, innovation, these are very calculable and credible. Whenever defense attorneys are coming up with innovation and dynamic efficiencies, then it's soft, incalculable. So I guess we have some more work to do to undo that dilemma and make sure that it's consistent. There's a question from Enno, and I can see that we're almost at the end of our time. So let's take that question. What are the effects of a settlement for damage claims? Can you argue that you did not participate in a cartel to defend? If you would like to respond from a US perspective, I'll then gladly respond from a Turkish perspective.
Sure, it's an interesting question, and it highlights too that I've sort of focused on civil matters and not talked about the leniency program on the criminal side and the effect of settling criminal matters. I think that as a practical matter, if you have settled sort of a criminal matter with the Department of Justice, you can expect follow-on private actions, and I think you can expect that your settlement will be used, at least atmospherically, against you in private litigation. Right? Settlements generally do not include an admission of wrongdoing, and so theoretically they should not be evidence against you in a private matter. But of course, usually there is evidence of wrongdoing. I think once you settle on the, sort of the criminal side with the government, you should expect that there will be, that there will be plaintiffs who pursue and will pursue successfully, damage actions. Now, who gets the money and, how it's apportioned between direct and indirect purchasers and who was harmed and who's a proper plaintiff, those are all questions that will matter in private litigation. But I think on the whole, it's not unheard of, but it is hard to, sort of avoid paying what I'll call a civil damage when you've settled on a criminal matter.
Yeah, the answer is very similar in Turkish law as well. So we don't have the criminal aspect of it unless the act in question also constitutes bid rigging in a public tender. So the only place where you can have both a competition law administrative investigation proceeding and a criminal investigation proceeding would be if there is bid rigging in a public tender. But apart from that exception, this is an administrative procedure in Turkey, which means you are looking at an administrative monetary fine at the end of this procedure, and you would be also looking at private litigations if there are persons or entities that are harmed, because the administrative monetary fine you're paying is going to the Turkish state, basically. And the party that is harmed by your act can say to a court, well, I don't care if they have been held liable and they have had to pay all these amounts. I have a separate account of loss. This should be calculated and then it should be trebled and given to me. This is an exceptional compensation matter for Turkish law, because when we teach Turkish law students the basic tenets of compensation, what we say is something that will not be very close to the heart of a US lawyer. That is, compensation cannot be enriching. So a compensation will only compensate for the damages, and it will restore you to the situation before the unlawful act. But you cannot be getting richer through the compensation. So punitive damages in that sense do not even exist in Turkish law. And going back to this discussion then, typically when the plaintiff goes to the court and says, I'm asking for all of my losses from and damages from the this particular counterpart who has settled, there is no bar in their ability to say this. And as a settling party, you cannot say that while you have settled, actually you don't believe that you have done anything wrong and all that. So basically, it's a very easy case for the plaintiff. Typically, if you have settled and if there are multiple parties, it's also going to be a joint and severable liability, and that will mean that you will have your recourse to the other entities, but you may have to pay up the entire damage of the counterpart and then go back to them and introduce a case against them, which is haunting settlements depending on the dynamics of the cases at hand. But there are very many cases where a settlement can be done despite what we have argued here, especially if it's a matter of abuse of a dominant position, kind of a case, to use the American jargon. If it's a maintenance of monopoly position type of a matter at hand, then these worries do not really apply, because there you don't have the same type of I would have been only in one drop in the ocean. There are so many other entities that would have received these claims. Now I'm bearing the burdens of all of those type of a problem. Last words, Bilal, and then I think we should be wrapping up as it has been an hour.
You know, no major last words. I'd say there are going to be changes in the U.S. At the federal level and I think also at the state level. Some of this was sort of inevitable, I think, but I think it's accelerated, and changes will be broader given the incoming and now new leadership at the FTC and the incoming and leadership at the Antitrust Division. The states tend to be more aggressive, I think. I think the only last word is I'd say if you're a party to one of these actions, respondent, defendant, and you think the agency has it wrong, your best approach may be to put them to litigation, as opposed to trying to convince them of your position, because I think there's going to be a hard line over the next few years, and whether that's appropriate or not, I think is an open question. But I think parties are going to have to be prepared to litigate and litigate quickly with the agencies to get some certainty on what the law is. And whether the agencies can move forward with this sort of more aggressive approach. So that's what I would think is sort of the key message for firms and representatives of firms. Be prepared to push back and be prepared to push hard, and litigation may be the appropriate way to do it.
Yeah, thank you. This was great. I hope it was well worth the time of people attending. And thank you for all these helpful insights. And I've learned definitely quite a lot from this process as well. Hoping to do this again with you, and thanking everyone for attending. I think it's time that we wrap it up. I don't have any last items that I want to go over, so we can leave everyone back to their business days.
Thank you
Brilliant.
too.
Couldn't have said it better myself, Gönenç. Thank you very much for your time today, Gönenç and Bilal. Fantastic webinar, and thank you all for being with us today as well. I hope you all have a lovely rest of your day and hope to see you all again soon.
Thank you. Appreciate it. Bye-bye.
Thanks, everyone. Bye.